Well, thank you so much for having me here today to speak a little bit about my book, A Debt Against the Living, An Introduction to Originalism. I'll say that the book has at least 3 virtues. It's short, it's only 135 pages, it's cheap, it's only $15, and it has a really great cover. Now, I also happen to think it has the 4th virtue of being correct. And that's what I hope to persuade you of, though I don't think this will be a particularly tough crowd compared to the law students that I regularly speak to. But I guess when I do this talk to the lawyers chapters, I do like to start by saying a few words about how I came about to write this book in the first place. Some of you might be wondering, wasn't there some introduction to originalism before 2017? Turns out there wasn't. So I was a law student at Stanford, and you may be surprised to learn that originalism is not really a thing. It's not really talked about. Why is that? It's probably a function of 2 things. One is the case method itself sort of lends itself to this common law kind of constitutionalism, this evolutionary precedential method of interpreting the Constitution. But even when we get to an originalist opinion, like say D.C.B. Heller, it's not taken very seriously. One anecdote, I tried to find the video of this to no avail, but I swear this is what he said. The dean of Stanford Law School was once asked in a conference on intellectual diversity, why aren't there more originalists on law school faculties? And he said something to the effect of, well, look, it's like asking a chemistry department to hire an alchemist. You just wouldn't do it. It's just, we think it's so crazy. Okay, so there I was as a student, and I'm like, I don't know, this originalism thing actually sounds kind of plausible to me. So I had to strike it out on my own and try to learn about it. And I looked for an introduction, and I couldn't find one. There are many good books written on originalism. You know, Randy Barnett, Keith Whittington, Jack Balkin all have books and terrific law review articles. And my book talks about a lot of them, but there was no just single narrative, single volume, single narrative, like short introduction to and defense of originalism. So I have done all the work for you in a slim 135 pages, and that is the origin of this book. Okay, so that's the setup. Now to the actual argument, what the book talks about. So my story here starts in 1789, when Thomas Jefferson was ambassador to France, as France was in the throes of the French Revolution. This is also the year that the Constitution of the United States went into effect. And in this year, Thomas Jefferson wrote a letter to James Madison, in which he said that the earth belongs to the living. The earth belongs to the living, not to the dead. The dead have neither power nor rights over it. One generation is to another as one independent nation to another. Now, Jefferson's letter is relatively well known. It's often quoted for the proposition that we shouldn't be bound by the dead hand of the past, by the dead hand of the Constitution. That the Constitution should instead be a living, breathing document subject to changing interpretations over time. But what's often forgotten is Madison's response. Madison wrote a letter back to Jefferson in which he said the following: if the earth be the gift of nature to the living, their title can extend to the earth in its natural state only. The improvements made by the dead form a debt against the living who take the benefit of them. This debt, Madison said, cannot be otherwise discharged than by a proportionate obedience to the will of the authors of the improvement. Okay, translation. Yes, Jefferson, you're right. The earth does belong to the living, but only in its natural state. The Constitution, Madison was arguing, is an improvement of such consequence, of such magnitude, of such importance upon the natural condition of the world that it can't but form this kind of continuing obligation against future generations, this debt against the living. And the only way for we the living to faithfully discharge that debt is through a kind of originalism, by a proportionate obedience to the will of the authors of the improvement. Okay, so who is right? Thomas Jefferson or James Madison? Well, it doesn't take a rocket scientist to infer by my choice of book title and my presence here today that I argue in favor of Madison, originalism, and the original Constitution. But, to make the argument, we're going to have to do something that's so rarely done in the literature, in the relevant literature, that's so rarely done in the law schools. and in the public at large. We're going to have to defend the founding. Because as I hope to make clear over my remaining 20 minutes or so, a full defense of originalism requires also at least a limited defense of the founding. Okay, to see why, let me back up and start with a definition of originalism. If for no other reason, Madison's letter sort of sounds like an old version of originalism you may have heard of, original intent originalism. Well, today we simplified things. Originalism stands for the proposition that we should interpret the Constitution with its original meaning, with the meaning its words would have had to the framers who wrote it and the public that ratified it. But I think originalism stands for an even more fundamental proposition. Originalism stands for the proposition that there are distinctions between what the law is, what the law ought to be, and whether that law is nevertheless binding. Here's what I mean. This is actually how we think of and conceive of other legal instruments in our legal system, like a statute, or a contract, or a treaty. Ordinarily, we first ask, what does this contract or statute even say? What does it do? What legal effect does it have? Now, once we've figured that out, it may turn out that we entered into a particularly bad business deal on one occasion. Or maybe Congress has enacted a bad law. But very much an integral part of our legal system is that we are nevertheless bound, even by the bad contracts that we've properly entered into, just like we're bound even by the bad laws that Congress enacts. Why? Why is that? Why are we bound even by Congress's bad laws? Well, because in our legal system, we maintain that so long as the laws are enacted pursuant to a particular process, a particular democratic process, right, the assent of 2 houses of Congress, a nationally representative president, that process is sufficient to confer legitimacy on the laws such that they are binding as a whole, even those of them we do not like. Well, can the same kind of argument be made about the Constitution too? After all, the Constitution is also a law, a law we the people enacted to bind our legal officials. So the originalist position, then, is that we first ask, what does this Constitution even say? What does it do? What legal effect does it have? What kind of constitutional regime does it create? But once we figure that out, we may not like all of its provisions. We may think it's imperfect. Maybe we think we could do better. But is there an argument that we are nevertheless bound by the Constitution as a whole, despite any imperfections it may have, just as we're bound by the laws of Congress as a whole, even those of them we do not like? So in short, for the originalist, there are 2 fundamental inquiries. The first is, how do we even figure out what this Constitution says or does? What kind of constitutional regime it creates? And the second inquiry is, okay, and is that Constitution even binding, such that we should care what it says or does, especially if we don't like everything that it says or does? Okay, so in my remaining time, I'd like to go through both inquiries, briefly. Starting with the first inquiry, which is the easier inquiry. How do we figure out what this Constitution even says? Well, the originalist position is that we interpret any legal instrument the same way we'd interpret any communication intended as a public instruction. In other words, interpreting the Constitution is in principle no different than interpreting a recipe for fried chicken that you find in your great-great-great-great-great-grandmother's attic that happens to carbon date to 1789 and was written in Philadelphia. Think about it. If you found such a recipe, how would you interpret it? Well, you'd use a public meaning, not a secret or esoteric or poetic meaning, otherwise it would be a pretty ineffective instruction. And you would use the original meaning, the meaning the creator of the recipe intended to convey at the time it was written. It's that easy, but Of course, that's not to deny the existence of interpretive difficulties as a result of indeterminacies, ambiguity, breadth, vagueness. So the Constitution, you see where this is going. So the recipe could say, add pepper to taste. Well, what the heck do we do with that? Whose taste is that? Does that vary from person to person, from time to time? Who gets to judge? So it will be the case that faithful chefs faithfully trying to implement this recipe for fried chicken will arrive at a range of plausible actual results in the world, a range of plausible actual outcomes of actual fried chickens. A range, yes, but a circumscribed range. A modern-day chef couldn't just add rosemary to taste instead of pepper because he or she concludes that modern-day fried chicken eaters prefer rosemary. I mean, the chef could do that, but make no mistake about it. That would not be interpreting the recipe. That would be amending the recipe. Well, the Constitution is also a public instruction from we the people to our legal officials. So we interpret the Constitution with a public meaning, right? Not a secret or esoteric or poetic meaning, right? And we interpret it with its original meaning, the meaning we the people intended to convey at the time we wrote it and sought to bind our legal officials, including our judges, respectively, who are also legal officials authorized by the Constitution. It's that easy. But again, not to deny the existence of those same interpretive difficulties as a result of those same indeterminacies. So it will be the case that faithful interpreters of the Constitution will arrive at a range of plausible originalist answers to many constitutional questions. For what it's worth, I think for too long, originalists defended originalism as though its key virtue was that it leads to one right answer. I don't think that's true. I think it's much more determinate than alternatives to originalism, but I think it's more accurate to say that often originalism leads to a range of plausible answers to many constitutional questions. A range, yes, but of course, a circumscribed range. Okay, so are we all originalists now? Well, you all are. The law students are always sort of give me this puzzled look still. Justice Elena Kagan says we are, largely on the basis of these kinds of arguments. But I don't think that goes far enough. I don't think that does enough work. Because the best non-originalist argument goes something like this. The best non-originalist argument would say, well, gee, Ilan, that's all well and good. We don't disagree with anything you just said. We just think it's beside the point. We don't disagree that there is this thing called the original public meaning of texts. We also don't disagree that ordinarily we give legal effect to the original public meaning of laws. We just think the Constitution is different, they'll say. Why is the Constitution different? Well, because it's particularly old, its principles are outdated and need to be changed, and it turns out to be exceedingly difficult to change the Constitution. Therefore, we shouldn't be bound by that Constitution anymore. If all of these premises are right, then non-originalism isn't crazy. Non-originalism would not be a crazy second best method of changing the meaning and content of the Constitution over time. Note that I don't think that makes non-originalism an interpretive method, right? It makes it a method of constitutional change, but I think nevertheless it's a perfectly plausible method. So to fully defend originalism, the originalist has to make the claim that the Constitution is binding law in the same way that, say, the laws of Congress are binding, such that we're bound by it, even the parts of it we don't particularly like. So what makes the Constitution binding, though? That's a really hard question. What makes a Constitution binding? Because it won't be the same thing that makes the laws of Congress binding. Well, in the book, I argue that the Constitution is legitimate and therefore binding law if it is an improvement of the kind that Madison describes in his letter to Jefferson. If it's an improvement that forms a debt against the living. Well, what must the Constitution do to be this improvement and to create this debt? I argue that the Constitution, to be legitimate and therefore binding, must accomplish one central task. The Constitution, at least a Constitution for a society like ours, for a free society, must accomplish one central task. the Constitution must balance the two competing primary objectives of a free society, self-government and liberty. On the one hand, this Constitution must create a regime of self-government, whereby we the people can govern ourselves, right, and choose who we want to be through our elected representatives, right, who we want to be politically, socially, morally, culturally, economically. On the other hand, this exact same piece of paper must also preserve a large measure of natural liberty. Otherwise, why would we have gotten out of the state of nature into this civil society thing, right? If we give up all of our natural liberty and natural equality that we had in the state of nature, we wouldn't get out of the state of nature to make ourselves worse off, right? So we have to also preserve a large measure of liberty. But what's the problem? What's the problem? These two objectives are in tension with each other. We all know it's often popular majorities that infringe on the rights of minorities. So writing a constitution that successfully balances self-government and liberty is no easy task. Now, to make this point, I'd like to quote from Edmund Burke's Reflection on a Revolution in France. I regret not having this in the book, but nevertheless, it's a good quote, and so I'm going to paraphrase anyways. It's pretty close, but it's not perfect. Paraphrase. So he says something along the following lines. To form a government requires no great prudence. Settle the seat of power, compel obedience, and the work is done. To create freedom, he said, is easier still. It is not necessary to guide. All it requires is to let go the rein. But to form a free government, that is, a government or constitution that successfully balances these competing objectives of liberty and restraint in one consistent work, requires a sagacious, powerful, and combining mind. Well, in the book, I argue that the framers were remarkably successful for their time at writing a constitution that successfully balanced these competing objectives through ingenious mechanisms, of which those here hardly need reminding, right? Separation of powers, checks and balances, the enumeration of power, and the division of federal and state power. The representative mechanism itself was a novelty at the time, and of course the provisions of the Bill of Rights. But more than that, and more importantly, the framers wrote the Constitution in a way such that it would continue to strike a successful balance between self-government and liberty long into the future, on both sides of the equation. Let's start with the liberty side. I mean, this is old hat for the seasoned veterans in this room. We all know that the rights-protecting provisions of the Constitution are written in sufficiently broad terms to be adaptable and applicable to new and changing circumstances. That's why the First Amendment applies to speech made on the internet. It's why the Fourth Amendment applies to GPS devices that police officers put on cars, right? 4 things the framers couldn't possibly have conceived of. What about the other side of the equation? What about the self-government side of the equation? Well, consider what the Constitution actually insulates from democratic self-government. Very little, astonishingly little. It insulates those rights most essential to free societies: free speech, press, religion, assembly, petition, self-preservation rights, if you will, in the Second Amendment, due process rights. But other than that, the Constitution leaves most questions, not all questions, but most questions, to the democratic process, precisely because the founders expected that we would evolve and progress over time. Right? If they didn't think we would evolve and progress, or didn't want us to evolve or progress, they would have baked more things into this Constitution, right? But they didn't do that. And of course, maybe this goes without saying, but I'll say it anyway. For the most fundamental of regime changes, they gave us the amendment process, which is in fact how it's been used. Okay. So in sum, if we the people today, here and now, not as a matter of blind veneration to the past, not because the founders said so, but here and now, today, conclude that the Constitution of our founders, as it has been amended, continues to strike a successful balance between self-government and liberty, then that Constitution is legitimate and therefore binding law, even if it's imperfect. I want to state the point in one other way, because it's the whole point. It's the whole argument. Something must make a constitution binding. It can't be that no constitution is ever binding. That's preposterous. Civil society would fall apart. We know that cannot be true. But it also can't be true that a constitution is only binding if it says exactly what you personally would want it to say. That also can't possibly be true. 300 million Americans might have a different opinion about that. There must be a middle ground. There must be a middle ground, something that makes the Constitution binding law, even if it's imperfect, even if it's not the exact thing you would have said. That something, I submit to you, is this threshold balancing of self-government and liberty. Okay, I'm almost done, but we're not quite out of the woods yet. The framers also believed, I think correctly, that for the Constitution to be worth more than the parchment on which it was written, it had to first receive the approbation of the people in an act of popular sovereignty, popular ratification. It is this ground that the framers are most often and correctly criticized. They are criticized for being all white, all male, many of them were landowners, and many, not most, slightly less than a majority, were slave owners. And that this precludes us from being bound by their achievement in the Constitution, even as it's been corrected. Even as it's been corrected. Now, there is no point in sugarcoating the founders. They were white, they were male. One might say whitewashing the founders. Okay, they were white, they were male, many of them were landowners, and many of them were slave owners. But we don't celebrate the framers for any of those things or reasons because they did not invent any of those things. The framers didn't invent slavery. Slavery had been universal up until the founders' time. The framers didn't invent the exclusion of women and the poor from the political process. Those too had been universal. Quite the opposite. We celebrate the framers for overcoming these historical limitations in important ways. We celebrate them, it sounds cliched, right? For writing for the first time in a foundational national document that all men are created equal, as a result of which writing, people forget, half the states abolished slavery or set a timetable for abolition between 1776 and 1789, the greatest emancipation of its kind in world history up until that point, according to the Princeton historian Sean Wilentz. We celebrate the framers for giving us the first free government of the modern world, a government committed to the principle of equality under law at that. Remember, the Constitution has no property requirements for holding federal office. The Constitution abolishes titles of nobility and hereditary privileges. These were the innovations. That's why we celebrate them. And of course, the body of people who would deliberate and reflect on the Constitution in the ratification process was broader than anywhere else in the world and any other time in history up until that point. So we have, of course, we have progressed since the founders' time, and a good thing we have. But we've done so, I submit, largely because we stand on the shoulders of their achievement. We stand on the shoulders of what came before. Okay, to conclude, I like to use an analogy. Or I should say, I like to conclude with an analogy to the 13th, 14th, and 15th Amendments. The Reconstruction Amendments, abolishing slavery, guaranteeing due process and equal protection of the laws, and guaranteeing black suffrage. Why do we rightfully feel bound by those amendments? Why do we rightly revere those amendments? Not because the newly freed men participated in drafting them. None did. Interesting historical point, many of the newly freed men did participate in the Southern Ratification Conventions, right? But of course, most didn't. We wouldn't need a 15th Amendment otherwise, and certainly none drafted it. We don't celebrate the Reconstruction Amendments because women participated in drafting them. Again, none did. Some may have participated in the Western Ratification Conventions, but again, most didn't. Otherwise, we would need a 9th Amendment, and certainly none participated in drafting them. The Reconstruction Amendments were written by long since dead white men. But we nevertheless rightly feel bound by those amendments, because those amendments were themselves an improvement of the kind that Madison described in his letter. They were an improvement upon the original Constitution of such importance, consequence, and magnitude that they continue to form this debt against the living today. Well, my claim is that this same argument can be made about the Constitution as a whole, as it has been corrected and perfected by those amendments and the amendments since. And if I'm right, if the Constitution is an improvement of the kind that forms this debt against the living, then the Constitution is a binding law. And if the Constitution is binding law, we interpret it the same way we interpret every other binding legal instrument, with its original public meaning. Okay, that's what I had for you. I will say, I tried to do that quickly. I'll say some other things that the book talks about that I didn't have a chance to get into in case it stokes some questions. You may have been led to believe that there is a distinction between textualism and originalism. In fact, I once attended a National Lawyers Convention of the Federalist Society titled Textualism versus Originalism, where everyone pranced about, proudly proclaiming that they were a textualist, not an originalist. For the life of me, no one could explain to me the difference between the two. I seem to be an idiosyncratic voice here. Properly understood, I don't think there's a difference between textualism and originalism. The book talks about the interpretation-construction distinction, which I also don't think is a thing. The book talks about the framers' method for sort of ascertaining ambiguous constitutional meaning, sort of their theory of precedent. The book talks about lawyers as historians, and the book talks also about how Brown v. Board of Education is an easy case under the original meaning of the 14th Amendment. Though if I get asked about that, I'll also cheat and resort to my forthcoming book called The Second Founding, an Introduction to the 14th Amendment, to make arguments about Brown v. Board. But this book also talks a little bit about that. Okay, and I do all of that in only 135 pages and for only $15, if anyone wants one after. In all seriousness, I am also happy inscribing copies of the book for you. I cannot promise that that will increase the value of the book, and for that matter, I can't promise it won't decrease the value either, but nevertheless, you're all lawyers, assumption of risk. So with that, I guess we have about 15 minutes for questions, or 10 minutes for questions or so. Or unanimous agreement is fine too. So if there's a question, was there back there? Yes, sir.
How can acts of Congress be binding if the Constitution is binding?
That is a great question. How can acts of Congress be binding if the Constitution isn't binding? Now, of course, to the progressives, the non-originalists, right, who don't treat the Constitution of our founders as binding, right, it's not like they completely ignore it. They do say they're bound by the Constitution. It just turns out that they're only bound by the parts that they like, or the parts that are so hard, right, to get around that they can't pull the wool over the eyes of the people, right? There are some things in the Constitution that are so clear and so explicit that even they don't purport to be not bound by them, right? Because the people would not accept it. They don't like equal representation in the Senate. No one is saying, but we're not bound by that rule, let Maryland have 3 senators or whatever, right? Same thing with the way the laws of Congress. The problem, though, is this Constitution to which they're bound looks like the document in the National Archives, but it's not actually. It's partly that document and partly what the judges say about it. They're bound by the legal rulings, the legal opinions of the judges. That's what they purport to be bound by. It turns out that what judges say will have 80% connection, maybe 70% connection, maybe 90% connection to the actual text, because most of it is in fact clear. But then they just purport to not be bound by the other 10%. And so it looks like the Constitution, but it's a different Constitution. It's the Constitution of our founders plus, adapted. The non-originalist judge is bound by the Constitution in exactly the way I say is impermissible. Remember, 300 million Americans can have a different opinion about how the Constitution could be better in any particular. My claim is if the Constitution meets this threshold for legitimacy such that it's binding as a whole. You can't just take the parts you like and take the parts you don't like, because again, 9 justices might have a different opinion. 300 million Americans might have a different opinion. And so that's how it turned, but that's a good question, right? That's a good question. Why are they bound by those parts and not by other parts? And I think the answer is because it's a bit harder to pull the wool over the eyes of the people when it's so explicitly clear in the text. I think that's the best answer I got for that very, very astute question. Justice Newby.
Yes, thank you. Can you talk a little bit from the 30,000-foot level with regard to originalism, textualism, and its acceptance in law schools, or it's at least being taught in law schools? I graduated in 1980. This was not a discussion at all. Yeah. So you can talk about that, and then in conjunction with that, the BYU project about
Corpus, linguistics.
Find, the precise meaning of terms as they might have been in 1787, or as they might be. I know as we interpret our state constitution, the different drafts, different periods of time, that type of lexicon would be very helpful.
Yeah, so taking the bird's eye view, certainly when I was a student at an elite university, this wasn't really talked about. The real question is, are things going to change now that we have a more originalist or formalist Supreme Court? You would think. But it's still, let me tell you, as an originalist who just recently went on the academic job market, it's still pretty freaking hard to get those jobs, right? It's still pretty freaking hard to get those jobs, right? I probably shouldn't opine on a camera about the reasons it's hard, right? But the point, there certainly seems to be this recognition, right, that, if we can find an originalist that we think isn't crazy, then of course we want one in theory. But in practice, are there many originalists that they don't think are crazy? I don't know. And so we'll see if things change in the coming years. Except a token or two, I'm not expecting, at a sensible state with a sensible dean at a school like mine, I'm not particularly optimistic, right, that there are going to be a burgeoning class of originalist law professors anywhere. So it's just not taken. It's still not taken seriously. As for the corpora, or this corpus linguistics, I think it's particularly useful. These databases that are collecting a bunch of collections of every sort of printed use of these terms. But I would caution over-reliance on them too. There's sort of a debate internal to originalism about whether we're actually bound to the original public meaning of the text, or are we bound to sort of the original legal meanings of the text? Because a lot of these provisions in the Constitution had legal meanings, right? Ex post facto clauses, habeas corpus, suspending habeas corpus, almost the entire document is actually written in legal language, right? Even the supremacy clause, right? Anything to the contrary in a state constitution or laws notwithstanding. That's a non obstante clause, right? I mean, it had a legal effect that ordinary people probably wouldn't have known about. Now, I think this debate is making much ado about not too much, okay? Why? Because it was a standard legal method of interpretation to take words by their original sort of public meanings, their most common significations, right? And the ratifying conventions showed great awareness of the fact that the Constitution was also written in legal language. And so there is overlap, right? But there are still cases where the public views it quite differently than maybe the legal terminology would have. One classic example is bankruptcy. Congress has the power to make a uniform bankruptcy law. Does that include insolvency laws? Turns out those were different. Bankruptcy in English legal terms was about creditors, assigning credit, restructuring creditor obligations, or I guess the debts to creditors. Insolvency laws were about debtor relief, which is very different. They actually debated this in Congress in 1840. And Daniel Webster said, look, bankruptcy means what the people expect it to mean, using its sort of public meaning, its ordinary language that includes insolvency, it includes debtor relief, and they sort of settled on that. So there's some tension about that. I don't have a final complete answer over what to do in those cases of tension. But I will just caution over-reliance on just everyday uses of words when the lawyers writing the documents and the lawyers who would have been bound by the document, more specifically as our public officials, might have actually understood the terms differently. So I've not resolved fully this tension, but it's a very interesting question. Sir? Yes, sir.
Can only a formal process then make the Constitution non-binding?
The question is, can only a formal process make the Constitution non-binding? I think the answer is yes, short of a revolution. I think that's right. So the two options are, right, I'm going to take back what I just said. I don't know if only a formal process is necessary to make it non-binding. One might say the Constitution of our framers today is non-binding in many ways. Did we decide that in any sort of formal process, or did it sort of just happen as government officials and judges started making deviations from the original meaning, and the people just acquiesced in it? In other words, what I claim makes a Constitution binding makes it, in some respects, normatively binding or morally binding. For it to actually be binding in practice, that Constitution also has to be accepted by some supermajority, substantial majority of the people as a matter of our rule of recognition. Right? This is HLA Hart called the rule of recognition. As a matter of present social facts, what we recognize today to be the fundamental law, to be the ultimate legal rules of our system, again, depends on social facts and what people actually think and say and do. In other words, I'm making an argument for why the Constitution ought to be treated as binding. But whether the Constitution of our founders will in fact be binding depends on convincing enough people of that argument. Right? The converse is also true, right? You can have a Constitution that's practically binding because it meets the present social facts, right? The society's rule of recognition. Maybe 85% of North Koreans really think they have a great Constitution. That makes it practically binding. If I'm the 15%, I'm going to go to jail, right? If I try to oppose this Constitution or whatnot, but that doesn't make it morally binding or normatively binding. You have to have both for the argument that I'm making to sort of work. So maybe the Constitution is no longer binding because we've undergone a kind of revolution, a constitutional revolution, through a very not formal process, through a very not formal war. It's just slow encroachments by political actors, including judges who are political actors, they're legal officials authorized by the Constitution, right? Making these encroachments. And so, as a matter of fact, the Constitution can be made non-binding through that informal process. Right? My view is the Constitution should be treated as binding, and therefore, if we're going to change it in some ways, because again, 300 million Americans can have a different opinion about that, it has to go through the formal process, which I think is good because it makes sure that there's that substantial majority of agreement to change that. And it's not just 1 out of the 300 million or 5 people on the Supreme Court, right? But as a matter of what actually happens, the answer is different. The answer is different. Yes, ma'am, and then, sure.
So I've heard the argument from some of, my law school professors, not that long ago, that, we have to, the Constitution needs to be a living document because otherwise the people would vote. Like, if it were not interpreted in this way, then people would, society would break down and, amendment and a constitutional convention are, impossible. Therefore, we need the judges to tell us, to basically, they really do say, change the Constitution so that it, that people will agree to be bound by it.
Yeah. Applesauce, as the great Justice Scalia once said. No, so there's something to this. So the argument would be, well, look, the reason our Constitution has been so successful is because judges have changed it in subtle ways, in minor ways, right? Well, my whole argument is that that doesn't have to be true. The whole argument is that the Constitution continues to strike this successful balance. It allows for flexibility. How does it allow for flexibility? By not baking too much into the Constitution, right? So I like to say that the Constitution of our founders may be dead, But the democracy they gave us is a living, breathing democracy. We the people can change and evolve and progress through our elected representatives over time. That's how they expected it to happen. That's why there aren't that many limits on what the states can do and on what Congress can do. There are more limits on Congress, right, than the states. So the question isn't, does the Constitution allow us, give us the potential to evolve? The question is it we the people who decide over time how to evolve? Or is it elite judges from Harvard and Yale who are going to decide how they think society ought to evolve? That's the question. The Constitution clearly allows for that evolution and that flexibility through the democratic process, right? It turns out that there are certain judges who don't trust people and don't trust democracy and would rather evolve into something that the society apparently does not agree with. So that's the question. I will say, by the way, that I do think the Constitution is, even on terms like, the Privileges or Immunities Clause, even in the terms of Commerce Clause, I do think it is more flexible than some originalists think. Like, respectfully to Philip Hamburger, and this is going to be a book someday, I don't think administrative law is all unlawful. I think it's about 20% unlawful, but that's a big 20% chunk, by the way. But for the most part, I think the administrative state's fine. Is Social Security constitutional? Probably. I'm not committed to that one, but But the point is, I do think the Constitution is a lot more flexible, both in that sense and in the democratic sense, than we're often led to believe. Yes, sir?
That fits in with the question that I was having. It's hard to frame, sort of. Is there a way to think of lots of administrative law as sort of, I guess, not only unconstitutional, but morally not binding, while still adhering to the idea of the Constitution itself is binding?
I think so. So the question is, well, if you think that there was this usurpation and much of modern administrative government violates that Constitution, can you treat the administrative regulations or things that they do as somehow not binding because they violate the Constitution? Or I see why it's hard to frame. I think the answer is, again, you can think they're not morally binding, because what's morally and normatively binding is this Constitution, this original meaning of the Constitution. You could think it's a usurpation, but it could be practically binding, just because that judges continue to enforce it, people continue to accept sending people to jail over it. So it has to be a Martin Luther King letter from a Birmingham jail situation, which is, I understand that in the society I'm in, these rules are practically binding on me, and so I'm going to protest, and I'm going to suffer the consequences. He never refused or resisted being arrested. He knew he would be arrested. That's just, and the only way to change it is to suffer that consequence and write those letters and convince people that it's an unjust result, right? So again, things can be practically binding, even if not morally binding. My whole argument, again, depends on convincing the American people of the normative claim, and so convincing enough of them to make that practically binding, right? It's a very tough question. This is a tough crowd. Go ahead, sir.
Sort of a related question. Given the amount of non-originalist jurisprudence, what do you think is the duty of an originalist judge faced with that question? In other words, the stare decisis issue.
Yeah. So my first answer is that the framers did have sort of a theory of liquidating and ascertaining ambiguous constitutional meaning, right? This is their theory of liquidation. Will Bode of the University of Chicago has a good paper in the Stanford Law Review called Constitutional Liquidation about this. The idea was that some provisions of the Constitution are ambiguous, indeterminate, right? Does the president have a removal power, a power to remove principal executive officers? Where does it say that in the Constitution? Well, there's the executive power clause, there's a take care clause, there's a necessary and proper clause. The point is there's a range of plausible answers to that question. Within that range, remember I said often originalism leads to a range of plausible answers. How do we fix on the answer within that range? And Madison's answer was through a series of discussions and deliberations and adjudications. Not a single Supreme Court opinion. Not a single Supreme Court opinion, right? A series of discussions and deliberations across all the branches of government and among we the people too, right? In the elections and so on. So I think the answer is, if there's a precedent that's not really answering your question, Many precedents, I think, are plausibly within the range of original meanings, once we sort of accept that. And if that's the case, that's the case. You can stick with those. What about the truly non-originalist ones, right? A smaller pool, but there are many, right, that are clearly outside that range, demonstrably wrong, demonstrably wrong. I think the answer is you overturn it unless expectation interests are so entrenched that the whole system would fall apart. Is there an originalist argument for following non-originalist precedent in that situation? Maybe. It's quirky. I haven't committed this to writing anywhere. But Abraham Lincoln violated the Constitution. He suspended habeas corpus. Why? Should the whole Constitution fall apart? Shall the whole Constitution be lost? Shall all federal laws fall out of execution in the South for the strict observance of one part of the Constitution because Congress is out of session during this emergency? Know what he did, though. He accepted he was violating the Constitution. He didn't pretend that, oh, well, I could violate the Constitution under my inherent emergency powers. There's no inherent emergency powers clause, right? But he justified it on his oath to preserve, protect, and defend the whole Constitution. Well, judges also have to support this Constitution, take an oath to support this Constitution. If they invalidated Social Security and everything fell apart and there would be riots in the street, right? Are you supporting this Constitution by doing that? Maybe not, maybe not. But it would be the extreme case of entrenched serious reliance interests, I think, where a judge probably shouldn't do it. But that's a hard question, and my book doesn't talk about precedent precisely because it's hard and I didn't want to commit one way or another. Yes, sir. Yeah, thanks for coming.
I have a parking meter that I don't consider to be morally binding, but it is effectively binding.
I promise the cost of the ticket will be worth it if you.
I'm curious, I think I heard someone say you spoke at Duke Law School yesterday.
Yes, sir.
I'm curious what kind of reaction you got from the students.
Everywhere I go, the students are actually quite respectful. You know, the real key, and maybe you all can help me here, like spreading the word, the real key is to get students at undergrad, in colleges, because they, believe it or not, still have reasonably open minds. Law school, you know, I do this talk, I sort of arm the Federalists with arguments that they otherwise wouldn't have. And yeah, sometimes a liberal student does come up to me and say, oh my gosh, I've never heard anything like this. Thank you for presenting this argument. But most are probably still skeptical, but the students are surprisingly respectful. No one has yet protested me, probably because they don't know what my book says yet. But you'll know I've made it when I get Antifa protests. I was worried when I went to Portland. I did a talk in Portland, and there were Antifa protests. Fortunately, not for me. You know, I think I have time for one more.
Just a comment relevant to this last question about
Yeah, please.
stare decisis. I remember watching an interview of Justice Thomas, and the interviewer had been one of his former clerks, and she asked, you know, what do you think of stare decisis? And he says, I have great respect for stare decisis, but I have even more respect for the Constitution itself.
That's very interesting. That's a very interesting anecdote. That's right.
Can I ask one
Yeah,
question?
please.
Evaluating the 5 conservatives on the U.S. Supreme Court, how many are originalists and can you identify?
At least 3, right? Possibly 5, right? So I think all of that, when you have a 5-person majority, generally, I think it'll be easier to just make thoroughgoing originalist arguments, right? Is Justice Alito originalist? I don't know, sometimes. Sometimes he just, I don't know, just does what's conservative, I think, probably. So it's yet to be seen, but I think there are 5. There are 5 mostly originalists, even if not, you know, full-fledged originalists, I would say. Well, thank you again for your attention. I'm around for another 20 minutes. I think you're still waiting for dessert, right? So you can all stick around for that. And I am a millennial, so I do take credit card. And it's only $15. So seriously, if you don't want it for yourself, get it for like your friend's kid who's about to go to law school or something like that. Anyway, or about to go to undergrad. It's readable. So again, I'm happy inscribing it. Thank you for your attention.